Morning and welcome to this morning's Archor webinar in conjunction with SICES. Hopefully for the next 50 minutes or so you will have a little bit of interest in something we're going to be talking about, and you will understand the aptly named title, let me tell you, the one about the Englishman, the Scotsman and the Irishman. So just before we start, there are a few little housekeeping notes. Firstly, the slides will be distributed to all those attending after today's webinar. Second, today will be recorded and the recording will be available on the SICES YouTube channel. And lastly, if we do have some time for questions at the end, then we will try to do so. There is a chat box function within the GoToWebinar software you'll be able to see on your screen. So please do feel free to add any questions. So hopefully we'll have an opportunity to answer them. But yeah, anyway, so without further ado, we'll get going. So I don't know how much you will all know about us, but we are a niche law firm specialising in construction, both contentious and non-contentious. We are based just outside Colchester and also in Cambridge. The firm is made up of 6 partners and there's 24 of us here now. And as I say, construction is all we do. My name is Ruth Kavanagh, I'm managing partner of the firm. I am delighted to be joined today by Megan Greene, who is a trainee with the firm, and she has been here since June 2021, and she spends her time dealing with both contentious and non-contentious construction. There are some mugshots of the partners. Have a guess as to how we came to the title or how we came to the name of Archor as the firm, but there are the 6 partners and here are some mugshots of the rest of the team. So as everyone knows, today we're going to be talking about NEC contracts and specifically compensation events. I've been doing this for a very long time, and whenever I get an NEC dispute, I can tell you now it's never anything about copyright. It's hardly anything about insurance. It's hardly often anything really to do with defects. 9 times out of 10, all of the pre-dispute work and the dispute work we do is all in relation to compensation events, how they arise, how they should be assessed, and what the chances of recovery are. So the programme for today, not the Clause 32 programme, but the programme for today. Firstly, Megan is going to run through the basics of compensation events, how they operate, and the way the process should work in practice. She is then going to look at some recent-ish case law. The first case she's going to discuss is from the High Court in Northern Ireland, and the second is from the Court of Session in Scotland. Both of these cases relate to how you value compensation events and whether you should be using actual cost or forecast cost. In part 3, I'm going to discuss the assessment of compensation events and how they are supposed to work under the contract. And I'm then going to give you some example scenarios and where I think an adjudicator would land in the event that you end up in a dispute. So I will now hand you over to Megan, who is going to discuss the basics with you.
Lovely. Good afternoon, everyone, and thank you, Ruth. Let's now briefly look at the basics. So the first point to make, and the quote slide is taken from the NEC guidance, is that when assessing compensation events, the parties do not use the rates and prices in the original contract, but rather the compensation event is assessed by reference to costs. I'm sure the bulk of you already know this, but those costs can either be forecast costs or actual costs. The key point about a compensation event under NEC is that the contractor should strictly not be penalised for something that is not their responsibility, the vast bulk of compensation events by their very nature typically being a change. Now, sticking to the basics, a compensation event is the only basis upon which a change to the prices or a change to the completion date can be made under NEC. For those of you familiar with JCT, there is no such thing as loss and expense under NEC. NEC prescribes the way an extension of time is assessed by reference to a prospective analysis to the planned programme, whereas JCT typically assumes there will be a retrospective analysis, and you consider the progress against the as-built programme. On the screen, you will see an extract from the NEC guidance, which sets out the way a compensation event should work. I'll be touching on most of these clauses shortly, but to briefly run through the clauses, Clause 60 defines what is meant by a compensation event. Clause 61 details how a compensation event is notified, whether by the project manager or the contractor. Clause 62 explains the process for submitting quotations relating to compensation events, and clauses 63 to 65 set out the rules for assessment of a compensation event, and in practice, it is the tidying up of any loose ends. The bulk of you on this talk are regular CICES attendees, and you'll be very familiar with the types of compensation event that exist. But there are essentially three types. Firstly, those triggered by the employer or project manager, which is typically a change to the works. Those compensation events are listed on the left-hand side of the screen. Secondly, those that are triggered by a failure by the employer or project manager to do something that they should have done. For example, a failure to give access. And thirdly, what might be considered a neutral event which occurs. For example, bad weather, which neither party is directly responsible for. All of these events, at least in the standard form of contract, are compensation events. Now, this talk is aimed at understanding recent case law and how it impacts the correct way to assess a compensation event. And as most of you will be aware, there is a requirement for any compensation event to be notified within the timescales under the contract. We are not going to spend any time on that particular issue today, other than to say that it is vital if you are a contractor and you are given an instruction by the project manager, you must notify a compensation event within the given timescale. The standard form says 8 weeks, but that is often reduced to as low as 2 weeks, so be sure to check your form of contract. There are in practice two ways for an instruction to be issued, either by the client side through a project manager's instruction or by the contractor via a clause 61.3 notification. Now, clause 62 relates to the quotation process for compensation events, and there are given timeframes within the standard form, which is often amended, that require the contractors to submit a quotation within 3 weeks of being instructed by the project manager. Then there is often a process of revised quotations and toing and froing between the two until an agreed quotation is accepted. The key point to stress here is that there is a process to be followed, and once an instruction has been issued, or the compensation event is notified by the contractor. Clauses 63, 64 and 65 relate to the assessment of compensation events. And the key provision is clause 63.1. Clause 63.1 makes clear that the method to assess the effect of a compensation event and its change to prices is a combination of the actual cost incurred and the forecast cost to be incurred. These two cost elements are then multiplied by the resulting fee, which is essentially overhead and profit. What decides when you use actual cost compared to forecast cost is the dividing date, and this is key. The dividing date is the date when the project manager issues an instruction for a compensation event, or in the case where a contractor notifies a compensation event, this is the date the compensation event is notified. What it is not is the date the parties get round to trying to agree what the value of the compensation event is some months later. For a well-managed contract, most compensation events should be primarily forecast cost only, because the client instructs the compensation event before it starts any of the work relating to the event. It is only when something becomes a compensation event during the process of carrying out the work should there be any actual cost element. So let's look at the situation where everyone is doing what they should do under the contract. The project manager instructs a compensation event. This request triggers the dividing date, being the date the project manager issues that instruction. The contractor should then provide their quotation, which should at this point be all forecast cost, or at best, a limited amount of actual cost, which they may have incurred already together with the majority of forecast cost. The project manager and the contractor then agree the quotation and it is implemented by the project manager. At that point, the compensation event is agreed. If the actual cost of completing the work is less than the implemented compensation event, which should be based on forecast cost, the contractor wins because the contract does not allow the employer to open that back up again. Similarly, if the actual cost is higher than the implemented compensation event, then the contractor loses because the contract does not allow them to open it back up again. So in practice, the parties agree a figure for the compensation event, and whatever the actual outcome, the agreed figure is the end of it. The problem is that the parties often fail to follow the process correctly or at all. The project manager may fail to issue an instruction, or the contractor may fail to issue a notification. These first two items are often not the problem. The problem more often being that the parties fail to provide quotations at all or get close to agreeing quotations. So how do you deal with a situation when one of the parties has notified a compensation event, but in practice nothing has happened since? Difficulty may arise later down the line when valuing a compensation event, because at this point the actual cost will be known. I will now look at two cases which say completely different things in relation to how compensation events should be assessed. Firstly, we will look to the Irishman, which says that we can ignore the provisions relating to forecast costs under the contract. And then we will look to the Scotsman, which says that the provisions relating to forecast costs must be followed. So firstly, dealing with the Irishman, I'm going to discuss the case of Northern Ireland Housing Executive and Healthy Buildings Ireland Limited from 2017. So this dispute arose from two NEC3 professional service contracts, where the consultant, Healthy Buildings, was instructed to carry out asbestos surveys on two properties owned by the employer, being Northern Ireland Housing Executive. The terms and conditions of the contracts were similar, so the court treated the two contracts as one. And the Northern Ireland Housing Executive issued an instruction on the 10th of January 2013, but contrary to the contract, failed to notify a compensation event. The work arising from the compensation event was then completed on the 21st of May 2013, and Healthy Buildings notified a compensation event. On the 19th of August and the 22nd of October 2013, Healthy Buildings submitted its quotations to the Northern Ireland Housing Executive, and on the 14th of November and the 21st of November 2013, Healthy Buildings' quotations were rejected by the Northern Ireland Housing Executive as having no impact on Healthy Buildings' costs. Now, notably, all of these submissions were outside of the timeframes as provided for under the contract. The compensation event related to compensation for an increased survey, and the parties disagreed as to whether Healthy Buildings' records of the actual costs were relevant to the assessment of the compensation event. The question to be determined was, when work has already been completed, how should it then be measured? Healthy Buildings then subsequently referred the matter to adjudication, and on the 24th of January 2014, the adjudicator decided in favour of Healthy Buildings that the costs were to be assessed on the forecast basis. The Northern Ireland Housing Executive complied with the decision and made payment to Healthy Buildings in accordance with the decision, but then they commenced a court claim against Healthy Buildings, which ended up in the Irish High Court. The Northern Ireland Housing Executive challenged the adjudicator's decision and claimed repayment of the sums paid to Healthy Buildings, and also counterclaimed for additional monies above those awarded by the adjudicator. The High Court then had to answer two questions. Firstly, did the NEC contract allow for the court to look at the actual cost or simply forecast time charges? And secondly, on a proper interpretation of the contract, does the NEC contract allow for an assessment of the events by utilising actual costs incurred by the consultant? So Healthy Buildings relied on clause 63.1 and argued that it was not obliged to submit its actual costs, as only its forecast costs were relevant to the assessment. This is because the work claimed by Healthy Buildings was executed after the 10th of January 2013, and this date was the dividing date, being the date of communication following an instruction. Healthy Buildings' position, therefore, was that the forecast costs are relevant in assessing their entitlement to a compensation event, and the work done after that date was in the form of a forecast. However, the judge decided in favour of the Northern Ireland Housing Executive, and this is because the compensation event had already occurred, the actual costs had been incurred, and the court favoured a retrospective analysis in assessing the claims. The court decided that evidence, such as timesheets demonstrating what Healthy Buildings actually did in that period, is not only relevant evidence, but clearly the best evidence to assist the court in challenging the compensation to which Healthy Buildings is entitled. The judge described using a forecast cost as a strained and unnatural approach, which is inconsistent with business common sense. The judge's position was that clause 63 should not be used to prevent access to the best evidence in assessing compensation events. Now, this case demonstrates a different approach to the one set out in the contract, and there is a Welsh principle, but I'm not going to try and pronounce that name, which asks, why should you guess when you have the facts? Because knowledge overrules speculation. Now, whilst this may seem to be a logical approach, what about when the contract says to do it another way? It could be suggested that this case renders one of the key parts of the NEC contract redundant and undermining the clauses described previously. If you just looked at this case by itself, the principle of forecast cost no longer becomes relevant, but this decision may benefit employers and encourage them not to notify and assess compensation events promptly in breach of contract, with a view to basing future assessments on actual rather than forecasted impacts. Fortunately, we now have a more recent Scottish case and the NEC contract itself, which says otherwise. So we will now turn to the Scotsman and the case of UK Grid Solutions Limited and Amy Power Services Limited against the Scottish Hydroelectric Transmission plc from 2024. So firstly, as the case is from Scotland, we are working with slightly different terms. What we would ordinarily refer to as a claimant is called a pursuer, and what we would ordinarily refer to as a defendant is called a defender. So in July 2018, the pursuers formed a joint venture called GE Amy, and in October 2018, the parties entered into an NEC3 engineering and construction contract with amendments. The works to be carried out by GE Amy included the construction of a new substation building, together with the installation and commissioning of the related infrastructure. But the responsibility for the delivery and installation of two transformers, known as SGT5 and 6, remained with SHE. As previously mentioned, SHE were responsible for the delivery and installation of the transformers. However, that was delayed, which gave rise to a compensation event known as CE 65518. The project manager made an assessment that CE 65518 had no effect upon the defined cost, completion, or meeting a key date. And GE Amy then rejected the project manager's assessment, and on the 26th of October 2022, GE Amy submitted their own assessment in respect of the impact of the delay associated with the transformers. SHE then rejected GE Amy's claim, valuing it at nil in their payer notice dated the 7th of December 2022. Then on the 6th of March 2023, G. Amy commenced an adjudication against SHE, seeking an order for payment in respect of an increased defined cost. On the 3rd of May 2023, the adjudicator then issued their decision, and the adjudicator decided that G. Amy was entitled to an increase in the defined cost. The adjudicator decided that the compensation event was to be assessed prospectively at the time when the PM, the project manager, had or ought to have instructed the contractor to submit a quotation. As such, the forecast cost was the appropriate way to assess delay arising from a compensation event. SHE subsequently refused to comply with the decision, and G. Amy commenced enforcement proceedings. SHE raised several arguments in defending the enforcement proceedings, for example, relating to the adjudicator failing to exhaust their jurisdiction because they did not address the material defences advanced by SHE. However, the most relevant argument was whether the adjudicator correctly assessed G. Amy's entitlement to a compensation event. G. Amy's position was that the impact of delay should be assessed prospectively from the date which the project manager had or ought to have submitted a quotation. G. Amy's position therefore follows clause 61.1 of the contract, which says that the assessment should be based upon actual cost. SHE's position was that the impact of delay should be assessed retrospectively, taking into account what had actually transpired as a result of the transformer delays. Their argument followed that the assessment of delay should be based upon the actual cost. Now, in their opinion, Lord Richardson agreed with G. Amy. Lord Richardson agreed with the adjudicator in that G. Amy were correct as to the approach to be adopted in the assessment of compensation events. The opinion reinforces that compensation events were to be assessed prospectively from the date when the project manager had or ought to have instructed the contractor to submit a quotation. It was decided that SHE should have made payment to G. Amy following the assessment of the compensation event in accordance with the contract. Furthermore, in the opinion, it was highlighted that payment should be made on a forecast basis in order to facilitate cash flow in the industry by encouraging parties to pay now and argue later. The court was also reluctant to interfere with the adjudicator's award unless the adjudicator acted in a way which was ultra vires, which was not the case here. In summary, the assessment of delay by reference to forecast costs prevailed over the actual costs, which can be directly contrasted to the position in the Northern Ireland case. We do not yet have an Englishman or woman, but the Irishman says one thing and the Scotsman says another. Our view is that the Scotsman is correct in almost all circumstances, but the Irishman may be correct when none of the parties have followed any procedure in relation to a compensation event. I'm now going to hand you over to Ruth, who is going to discuss what should make up the assessment and where this all leaves the contracting parties now.
Thanks very much, Megan. So, as I say, this webinar is not to go through and discuss exactly how you should assess a compensation event, but I think in the context of the scenarios, I think it's helpful just to briefly recap on what the contract says in terms of how you assess. So just starting with how you assess the prices, obviously Megan has mentioned their defined cost and the reference to forecast versus actual. Defined cost is defined in the contract by reference to the short schedule of cost components for options A and B, or the schedule of cost components less disallowed costs for options C to E. So contained within those as part of the NEC contract, as many of you will be aware, there are categories of costs that can be claimed in respect of people in the working area, in respect of equipment, plant, and every type of possible head of cost that you could potentially think about, save that where it's not listed in those, it is to be covered in the fee. So the contract data in the NEC also has a section in it for rates which are to be applied. And so when looking at how to assess your compensation event, one of the things you need to be doing is looking at the contract data part 2 as well, because that does set out some rates. As I've just said, or as Megan said as well, defined cost therefore is then multiplied by the fee. The fee is a percentage, and clause 52.1 makes it very clear that all of the contractor's costs which are not included in the defined costs are treated as included in the fee. And the defined cost includes only amounts calculated using rates and percentages stated in the contract data, and other amounts which are open market rates less any deductions. So that makes it very clear it is defined cost plus the fee and nothing else. And if unfortunately you don't find a head of cost listed in your schedule of cost components, then it's deemed to be included in the fee by virtue of 52.1. So how do you assess the change to the prices? Well, there's absolutely nothing to stop the parties agreeing a lump sum change. Clause 63.2 makes that very clear in the contract. So there is nothing to stop that happening. And if the parties agree it during in the course of the contract, then in my view that is an agreement which stands, and then the only reason you could potentially open it up or revise it is potentially via the option W2. But if it's agreed, I would say an adjudicator might be strained to then decide something else. I guess it would depend on the facts. So just assessing time, whenever anyone says to me I'm entitled to an extension of time under NEC, I often slightly wince, because the reference to an extension of time, that wording does not appear in NEC. It's all about the adjustments to the completion date, or the effect of the compensation event is an adjustment to completion date. In respect of assessing delay, clause 63.5, this is an NEC 4 in the 2017 version, says that delay to the completion date is assessed as the length of time due to the compensation event. Planned completion is later than planned completion, as shown on the accepted programme current at the dividing date. So it is all about a perspective, it's all about an analysis with reference to the accepted programme as at the dividing date. Now, interesting, there's a last sentence in that clause which says, when assessing delay, only those operations which the contractor has not completed and which are affected by the compensation event are changed. Now, when the NEC 4 came out, NEC were pretty quick to issue a guidance note and amend that clause 63.5 when they published an amendment in January 2019. And the last paragraph has been deleted, or that last bullet point has been deleted and replaced with the wording that you can now see on screen. And that is to essentially make it even more prescriptive about the way you should be assessing delay and the way that you should be impacting it onto the accepted programme as at the dividing date. It's all about the dividing date, and therefore you are dealing with a prospective analysis at that stage. So it's just helpful to remember that, I think, in the context of these cases as well, which did talk about cost and not necessarily the programming. And what was the reason for this amendment? Well, the NEC basically said it's been made to embed good practice and provide further clarity in respect of how you assess delays. So you can see the reasonings there on the screen in relation to it should be taking into account events which have happened between the date of the acceptance of the programme and the dividing date. And so that would be other CEs. So what it's essentially saying is that you impact the CEs onto the accepted programme by reference to the dividing date, and therefore the order in which they appear, the chronological order in which they appear by reference to the dividing date. So that was just the NEC trying to make it abundantly clear to the parties about the way you should be dealing with programming. So some people might think it's all really unfair, and that the prospective assessment is unfair because you don't know how long it's going to take. Now, the whole ethos behind the NEC contract is to achieve certainty over accuracy. So it's to give both parties certainty at the time the event arises, or maybe doesn't arise in the end. The time the event arises, to give that party accuracy as to how long it's going to get and what it's going to get under the terms of the contract in terms of relief, i.e. time and money. It is simply prospective assessment. It's a forecast cost, which the reality is that all contractors do when they're estimating at tender stage how long the job is going to potentially take them and how much it will cost before entering into the contract. So now, just quickly, there are some deemed acceptance provisions in relation to quotations, and also actually, in fact, in relation to it being a compensation event. But these are kind of a deemed acceptance provision that are there to try and push the project manager along / push the contractor along under the subcontract to actually administer compensation events as and when they arise. This clause 62.6 is a provision which allows the contractor to notify the project manager they failed to accept the quotation, and then if the project manager then doesn't respond to that notice within a certain period of time, that is deemed to be accepted under the contract. And you've got the same here as well, where the PM doesn't assess it. If he says he's going to assess it and then he doesn't, then again, you give them a prompt notice. If they don't do it, then that notification is treated as accepted by the project manager of the quotation. So it is a useful tool for the contractor during the works under the main contract to try and push the parties along. The only thing I'll say in relation to these clauses is that it can be opened up in the event the parties go to adjudication. Option W2.34, which kind of reflects what the scheme talks about, says that the adjudicator may review and revise any action or inaction of the project manager or supervisor related to disputes and alter a manner which has been treated as accepted or correct. And just quickly, I'm just going to touch on implementation and clause 66. Deemed acceptance does lead to implementation under the contract. You see the third bullet point there. It says a compensation event is implemented when a contractor's quotation is treated as having been accepted by a project manager. And what it does go on then to say is that the assessment is not revised except as stated in these conditions. Again, I think except as stated in these conditions means that it could be revised in an adjudication, but in circumstances where a party has given a forecast cost, a quotation with a forecast at the time, my view is it can be opened up by the adjudicator, but I still think it should be within the realms of dealing with forecast rather than necessarily opening it up to decide that it should be actual cost after the event, because that favours the client. So that's the kind of backdrop potentially for some example scenarios that I'm now going to talk about. And I could have sent these out as questions before, but I thought I would just talk through them anyway. So scenario 1, day 1, C event occurs, the contractor notifies. So as we know from what Megan discussed earlier, that is the dividing date. The project manager accepts it and instructs a quotation, happy days, or comply with the contract. The contractor now has 3 weeks to submit its quote. So the works start on day 6, the works complete on day 13, contractor submits its quotation on day 23, and then the project manager's got some time thereafter to reply or make its own assessment. So the next question is then, how should this be assessed? Well, we know that under the contract, it should be forecast cost. The contractor, when it submits its quotation in accordance with the contract, should be submitting it all based on forecast, because as we know, day 2 was the dividing date. So that is the date, the dividing date, and it basically says that anything up to that date is actual, anything after that is forecast. You can see an adjudicator in these circumstances being tempted to consider actual cost, because at the point at which the contractor submits its quotation, all of the works have been completed. However, my view is that it should still be forecast cost, and that is the whole point of the NEC contract. As I say, this is no different to any other dispute we get, and often, as I say, there is an argument as to which it should be. But put it this way, the contractor is going to be in a lot better position to argue forecast if it has actually submitted a quotation as it was required to do. Scenario 2, a similar set of facts, save that a lot easier in that the event occurs, the contractor notifies, the PM accepts and instructs a quotation, the contractor submits a quotation, therefore all on forecast, the works start, the works are finished, and then you've got the dates for the PM to reply. In that instance, the quota has been given before any work has been started, and the dividing date was 3 days before that. But the PM is still considering it after the work's complete. Again, my view is the contractor will have submitted that based on forecast. The PM should be dealing with it as forecast. However, the problem does often arise when the PM then comes to reply and or assess it, in that whilst scenario 2 is all after the works are complete, the PM will then try to rely on clause 64.1, which says if the project manager decides the contractor has not assessed the compensation event correctly in the quotation and has not instructed the contractor to submit a revised quotation. Now, I would say, well, the contractor has assessed the compensation event correctly because he's used forecast cost, which is what the contract tells him to do. The project manager will try and argue to say, well, the contractor's quotation is incorrect if the actual costs incurred by the time the project manager considers the contractor's quotation are known and they are different to what the contractor forecasted. The result of which the project manager will say, well, he's entitled to do his own assessment. As I say, in this case, I would say it should still be forecast, and Keating on NEC basically agrees with it. And as it says on the screen here, however, despite this, certainty and efficiency are brought at the expense of accuracy to some degree. Save by agreement under clause 62.5, neither the project manager nor the contractor is permitted to wait so they can assess a compensation event once the actual effects have materialised. So looking now at scenario 3, in this instance, a compensation event occurs, contractor notifies, the PM ignores the notification, doesn't instruct a quote, the contractor submits a quotation, the works start, the works are finished, and completion of the works, the actual contract works, occurs some days later. Now, how should this be assessed? Well, the contractor has given a quotation without an instruction to provide one. My view is that the adjudicator is likely to be convinced it should be forecast. I don't think that the client should be able to benefit from its own breach, or should I say that of the PM, in failing to instruct the contractor to submit a quotation. Provided the contractor has forecast it properly, this could be a win-win for the contractor. The contractor can forecast certain risk allowances when providing its quotation. Clause 63.8 says the effect of a compensation event includes risk allowances for costs and time for matters which have a significant chance of occurring and are not compensation events, i.e. the contractor is entitled to include risk allowances for matters that are its own risks. Obviously, the downside to this scenario and it being forecast is that if the contractor is under forecast, it could potentially be stuck with it. So turning to scenario 4, the event occurs, contractor notifies, that's your dividing date, the works start, the works complete, all the contract works are then complete, and then the parties argue about the value of the compensation event. Now, this is, as we heard from Megan, similar to the Northern Ireland case. The strict contractual answer is that this should be based on forecast. The problem you have is that nobody has operated the assessment procedures under the contract to deal with actually getting this compensation event assessed. Yes, there's been a notification, but there's been nothing else. And the question is, what has the adjudicator got to consider in terms of forecast information at the time when none has been provided, none has been exchanged? My issue with this is I think that the reality of the situation could potentially override the terms of the contract, and that despite the wording, I think the adjudicator would actually want to consider the actual cost in relation to this compensation event. Now, lastly, scenario 5. This is the shortest one I've got. Compensation event occurs, works start, the work's complete, as in the compensation of works complete, and all of the contract works complete then, day 150. The question is, how should this be assessed? Should it be forecast or should it be actual? Assuming that the wording of the NEC contract has been amended in respect of clause 61.3 in terms of the notification, in terms of the last sentence of 61.3, which says the contractor must notify unless the compensation event arises from giving an instruction of or a changing of a decision. If that last bit of wording has been removed, my view is that this compensation event should be assessed as nil. It is a compensation event under the contract, but the problem that you have got here is there's been no notification of that compensation event under the contract. A little bit of a trick question. There is no evidence in this set of facts that it arose from the instruction, which would relieve the burden of the condition precedent clause, the notification clause at 61.3, and therefore for the requirement for the contractor to notify. Now, under clause 61.3, that will confirm that in the event of no notification, then there shall be no change to the prices, key date, or the completion date as a result of that failure to notify. So scenario 5 is a little bit of a trick question because there won't be any change at all. Unless, of course, somebody can argue, well, it's tricky, is all I'd say. If the project manager notified, fine, but due to an absence of notification there at all, I think that the contractor is going to be have some difficulty obtaining any relief from damages in the event this caused a delay, and it's going to have great difficulty in claiming any kind of cost for this compensation event. So we've cantered through that today, 45 minutes or so. Hope that has been of interest to those attending. I don't know if we've got any questions. Oh, someone's asked me something here. How do I just pull this up? Let's have a quick look. Oh yes, we've got a lot of questions. Oh my goodness. Someone said my microphone was off. Hopefully people can hear me now. The 8 weeks time bar for notifying a CE doesn't apply in relation to PM instructions, as the CE should have been notified by the PM when the instruction was issued. Could it not be argued that in healthy buildings, the court was changing the decision of the employer and thus the value of the CE is based on defined costs at the dividing date is now the date on which the decision was changed? Yeah, I mean, tricky. I think obviously if the PM changes the decision, that does give rise to another compensation event in any way. I agree with you also that in respect of the notification of compensation events, there is under the standard form an onus on the project manager to issue the separate notification, because under clause 13 under the NEC, we know that the notification is meant to be issued separately under the contract. But often, you know, it's very rare that I see the rest of that clause 61.3 in the contract. So often, if there's anything to be amended, it's often that. Think, yeah, the answer is yeah, potentially the court was changing it, but it's entitled to. You know, W2 says that an adjudicator is entitled to. Obviously, you have to go to adjudication first, but you know, the court was looking at. I'm just working out. I don't know if Heather was able to take control of this screen to make these questions slightly larger.
Ruth, you know, on the blue bar that you can see against the questions, there's a cross, and just to the left of that, there's a little box. If you click on that, it should enlarge it. Has it worked?
No. Ah, there we are. Better. Fine. Okay. Sorry, I'm being a bit silly here.
Is it tiny text, Ruth?
Yeah, it's just a bit small.
Okay. So can you see the blue bar? Sorry, everyone. Can you see the blue bar? And it's got a cross on the right-hand side.
Yeah.
Okay, so just to the left of that cross, there's a little box with sort of a line in.
That's completely gone now. Yeah, now it's gone. Yeah, I can't see it.
Right, just let me go into the questions, right?
Sorry, go ahead. Practice that bit before. Done it for a few months.
Oh, okay. Oh, there's some real lengthy questions here.
I mean, some of them I'm happy I'll go back and answer afterwards if that helps. If they're quite
okay,
lengthy.
yeah. If you've got a spare 2 days.
Somebody will have a spare 2 days. Okay, I don't know if you can put them in the chat, maybe instead. Yeah, I don't want to. Yeah, okay, I don't want to mess about with this in case I'm saying press the wrong thing. I'll run through the questions, and if there's some questions that I can be dealing with, then I'll look at them after today and then pop some answers through to Heather if